Welcome to today's program titled Drafting Restrictive Covenants That Work, Insights from Recent Legal Battles. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to Dawn and Dallin.
Thank you so much, and thank you to everyone who is joining us today. We know you're all very busy, and I really appreciate that you've taken time out of your busy day to join us. So we will be talking today about drafting restrictive covenants that work. Sort of the impetus for this presentation is Dallin and I are litigators who frequently litigate restrictive covenants matters and also advise clients on their agreements. But I'll tell you that one of the worst feelings as a litigator in this space is when a client reaches out to you and says, we have a former employee who has violated their agreement. We want to enforce it. Can you prepare a lawsuit and a motion for an injunction? And you look at the agreement and you realize it's not enforceable, or the enforceability is on shaky grounds. And then you have to go back to the client, even if you didn't draft the agreement, you have to go back to the client and say, I'm sorry, but you're going to spend a lot of money and you're probably not going to win, or maybe you definitely are not going to win. So this webinar will hopefully give you some tips as to how to prepare agreements and be aware of the various state laws and rules so that you don't have that scenario when somebody leaves and goes to a competitor. So we'll show you just some of our introductory slides. Next slide, please. Obviously, here's your typical disclaimer. You should consult with counsel if you have questions. Next slide, please. As I said, Dallin and I are both litigators who do a lot of work in this space. We're both in the Boston office, and we are happy to share our expertise with you today. Next slide, please. So we're going to show you the agenda. Next slide, please. So we're going to talk first about generally the landscape for restrictive covenants. There are a lot of different rules, and there have been changes over the past several years, both in legislation, but also in various cases. So we'll talk a little bit about that. One thing that I think a lot of folks believe is that you really need to watch out for non-competes, which is true, but it's not just non-competes that are subject to these strict rules and requirements. So we'll talk a little bit about that. Many of you may have heard about some activity in the last couple of years from the FTC and the NLRB. We'll provide you a quick update on that front. And then we'll talk a little bit about what we can learn from all these new rules and things that have come down the pike in case law. So next slide, please. So the current landscape, as I said, we really have a broad range of rules and requirements. Let's go to the next slide. 50 states plus DC, and we are starting to see some efforts to incorporate even more changes at a local municipality level. And that really means that we have just quite the patchwork of inconsistent law across the board. And as of right now, we don't have a national standard for restrictive covenants. That may come at some point in the future, but for the time being, we have to be aware of what each jurisdiction requires. Next slide, please. We could spend truly hours talking about the various changes in the different jurisdictions. We're obviously not going to do that. We have a lot we got to get to today. But here are some common themes that we have seen, especially in legislation in the last 10 years or so. First and foremost, wage thresholds. So there are about a dozen jurisdictions right now that have a wage threshold, meaning if an employee or an independent contractor, as the case may be, makes under a certain amount per year, they cannot be bound by a non-compete or perhaps a non-solicit in some jurisdictions. Now, the confusing thing here, wouldn't it be easy if in those 12 jurisdictions it was all the same threshold? That is unfortunately not the case. All of the jurisdictions, as far as I'm aware, have different thresholds. Many of them change on an annual basis. So it's not like, okay, we know for the next 10 years, somebody makes $100,000 and we'll be good. They change on an annual basis. And some of them change based on formulas that are not easy to identify in advance. So a couple of states tie the wage threshold to cost of living increase. So you might find out in December that next year, Washington's threshold is going to be something like $173,000 and 87 cents. It's not always nice round numbers. Some states do have that, but some don't. The other thing I will just mention before we go to the next bullet point is that even how you determine what the wage threshold is can be confusing. I'll use Washington again as an example. Washington is pretty quirky because it's not just what is this individual's salary, it's what is the number in the box on their W-2. And so you could have two employees doing the same job, technically making the same salary, but one contributes more to their 401k, and therefore the amount in box 2 of their W-2 is lower than the other employee who makes the same exact amount. One of those might be bound by a non-compete, and the other is immune from being bound from a non-compete. So again, it's very quirky, and it's important to understand what these wage thresholds are and how they will change over time. Forum selection and choice of law limitations. Dallin's going to talk a little bit about this more later in the webinar, but just to give you a sense, there are a number of states where the legislatures have passed some statute providing certain protections to their employees, and they say, we don't want some out-of-state employer making an end run around this protection that we have tried to enshrine for our residents here. And so the statute might say you can't have a non-compete for a resident of this particular state that includes a choice of law other than this state's law, because we don't want to avoid the protections of the state. Or you can't try to enforce that non-compete or non-solicit in another jurisdiction. This person has a right to defend themselves in their home state. Notice requirements are also a pretty popular new trend. This requires the employer to either provide a copy of the agreement or at least provide notice to the individual that a restrictive covenants agreement will be required as a condition of employment. And again, the rules here are different based on the states. Not all states have this, but a handful do. Some of them, it needs to be no later than the acceptance of the job offer. Sometimes it needs to be a couple weeks in advance. So again, this is really a patchwork of requirements. A lot of these statutes have presumptions of reasonableness or unreasonableness. So, something that's over 18 months is presumptively unreasonable, but if it's less than 6 months, it's presumptively reasonable. Right to counsel provisions, there are a couple of states that include this, and the idea is you need to put in the agreement that the employee has a right to consult with counsel of their choice before they sign the agreement. One thing that I think is really concerning for employers is we are seeing more and more states include in their statutes penalties for failure to comply with the statutes. So it's not simply that if you do it wrong, if you don't comply with this rule or requirement, your agreement will be unenforceable. In some of these states, if you don't do it right, if you seek to enforce the agreement, the employee might be able to get their attorney's fees. Or even if you don't enforce, California is a good example, even just having in the agreement non-compliant covenants, the company could face liability. So that's something that we really need to keep an eye on. And then there are a number of industries where there are specific state rules that either limit or ban covenants. We won't go into all of them. The one that I will say is the most prevalent, especially in the last few years, is healthcare. There are about half the states now have a statute that either limits or prohibits covenants, restrictive covenants in the healthcare industry. And then, of course, we have 4 states that ban virtually all non-competes. California, Oklahoma, North Dakota, and Minnesota is the most recent one. So next slide, please. There are some other state-specific things you should be aware of, whether they are in a statute or not. So continued employment versus new consideration. In roughly half the states, if you try to give a new agreement to somebody who has already been employed for a particular period of time, you need to also give them something as consideration. You can't simply say, here's this agreement we want you to sign. If you don't sign it, you're out of here. But the other half of the states, roughly, you can say, if you want to remain employed here, you need to sign this agreement. So that's something, again, that is important to be aware of. What is sufficient consideration? That's a whole other thing that, again, we could spend a ton of time talking about. It's really fact specific, and it can be jurisdiction specific too. Blue penciling and reformation. This refers to whether a court can limit an agreement that it deems too broad. So I'll give you an example. If there's an agreement that has a 2-year restrictive covenant, a judge might say, 2 years is really too long. I think 1 year is appropriate. In a reformation state, the judge can essentially strike out the number 2, write in the number 1, and then say, okay, we're going to enforce this for a year. In blue pencil states, courts typically can't do that. They can strike out offending language, but they can't add anything in. So if you have a list of 5 states and the judge says, it really should be limited to 1 state, okay, the judge can strike out 4 states and the 1 remaining state, it's fine, and the judge can enforce it. But in my duration example, if you're striking out the 2, you can't add a 1 back in, and then the remaining agreement is just, it doesn't make sense, it's too broad, and the court's not going to enforce it. There are also a handful of states, very few, but there are a few, where you really can't do any modification, whether it's blue penciling or reformation. If you draft the agreement too broadly, the court is just not going to enforce it at all. Finally, confusingly, some states refer to what is really reformation as blue penciling. So again, you need to understand what the case law in these jurisdictions says. Different states take different policies as to the enforceability of these agreements against discharged employees. Some states say you can't enforce, if you have terminated someone without cause, you really cannot enforce any covenant against them. But maybe you can if they were terminated for cause. Again, the rules are different based on the state. A lot of this is going to be fact specific, but that's another area where we see a big difference across the various jurisdictions. And then finally, tolling provisions. So if an employee has violated their agreement for, let's say, 6 months before the former employer is able to get an injunction, the question is, can we tack that 6-month period onto the end of the duration when the non-compete or non-solicit otherwise would have expired? And this depends. In some cases, some states will say yes. Some states will say yes, but only if you have an express contractual provision that says you can do that. Other states say, no, you can't do it at all. So we need to be mindful of that when we are drafting our agreements. Next slide, please. So again, I've already thrown a lot of state-specific quirks at you, and we can't go into every single strange rule of every jurisdiction, but I am going to call out a few quickly here. In Alabama, you can't have an agreement, or you won't have an enforceable agreement if you ask someone to sign their non-compete before they are officially employed. So you have to wait until the first day. California is, as many of you I'm sure know, kind of a wacky jurisdiction. Basically, all non-competes and customer non-solicits are void and unenforceable. There's a sale of a business exception, but really most employment covenants like this are unenforceable. With respect to employee non-solicits, the case law isn't quite as clear, but it's pretty darn clear at this point that you really should not be using employee non-solicits in your California agreements. And more importantly, there's a relatively new law that requires employers to send notices to not only current employees, but in some cases, former employees, if those current or former employees have agreements that include non-compliant covenants. And that notice needs to tell these individuals your non-compete or your non-solicit is not enforceable, and we will not enforce it. Colorado is an outlier in that you need, in addition to your general restrictive covenant agreement, you need to have a separate document that puts the individual on notice that your restrictive covenants agreement at Section 7 includes a non-compete, and that could impact your ability to get employment at certain places after you leave the company. It can't be in the agreement itself. It has to be a separate document. Louisiana is also kind of an odd state. Louisiana doesn't have counties, they call them parishes, and you need to identify the parishes in which the covenants will apply. It's not enough to say, oh, this non-compete and the non-solicit, they will apply in all parishes in Louisiana. You need to specifically identify each and every parish if you want it to apply in each and every parish. And just like Alabama, you really should only have individuals sign on their first day and not before they become employed. Next slide, please. Maine is another odd state. There is a delay for enforceability of a non-compete. If you have someone who joins the company, signs a non-compete on their first day, and then they leave after 6 months, you're not going to be able to enforce that agreement. Because Maine's statute provides that you can only enforce a non-compete 6 months after they sign the agreement or 1 year after the person started employment, whichever is later. Massachusetts has a number of quirks, including some of the ones I talked about a few minutes ago. The wage threshold, notice requirement, right to counsel. But one thing that's not in the Massachusetts statute, but is a really interesting facet of Massachusetts law, is the material change doctrine. As far as I'm aware, Massachusetts is the only state that has this. And basically, it's a common law concept in which the courts have said, if an individual's job conditions or responsibilities have changed in a material way and the employer doesn't get a new agreement, then the covenant is going to be deemed to have been abandoned by the employer. Now, a little caveat to that, you can include in your agreement a provision that says any change, material or otherwise, will not impact the validity of these covenants. And courts have almost universally, if not universally, upheld those provisions. So you can avoid falling prey to the material change doctrine, but again, it's something that you need to know and put in your agreement. Oregon, employers need to provide a copy of the agreement after the employee leaves if they want the covenant to be enforceable. Washington, as I mentioned, is a really interesting state with a very draconian statute. One thing that we haven't mentioned is that Washington has this retroactivity provision, which is very odd. And basically, if an employer entered into an agreement in 2018 that was completely compliant at the time, but doesn't comply with the new 2020 or 2024 amendment, the rules, then the employer is not going to be able to enforce the agreement, even though at the time it was entered, it was completely compliant and enforceable. And then finally, there are a number of states that have specific language that either needs to be in the agreement itself or posted where other notices to employers are posted. So as you can tell, that's a lot of really interesting, quirky requirements, and it's important to have someone who knows what the various states require and what they prohibit. So let's go to the next slide, please. And Dallin's going to take over from here.
Thanks, Don. So we're going to talk a little bit about venue and choice of law provisions and jurisdictional issues more generally. Oftentimes we refer to this as conflicts of law type analyses, which is really, really boring usually, and certainly not the sexiest thing to talk about. But it's becoming increasingly more important, in large part due to a lot of the statutes and rules that Don just referenced, because they create these conflicts between the various states where an employer might be located and where their employees live. And laws of those jurisdictions say different things about the enforceability of those agreements. So a question that is increasingly coming up in litigation is, well, what state's law apply? And as you can probably tell from Don's presentation, you can no longer rely just on the choice of law provision where the employer is located, which I think historically has often been the way that employers have set up their agreements, is say, hey, I'm an employer that's located in Massachusetts or Pennsylvania or wherever, and so I'm going to have all my employees' employment agreements governed by the law of my home state. And that's simply not going to fly in today's environment. Don referenced a few of these, but we'll go over them again real quickly. Many states are passing legislation or have had legislation for quite some time that prohibits requiring employees to litigate outside of their home state. California, we'll pick on California a lot here. Full disclosure, I was born and raised in California, love California, but their laws do create some problems when it comes to enforceability of restrictive covenants, and probably has like Don said, the most draconian one, where not only is a non-compete void, regardless of where it was entered into, when it was entered into, so long as the employee is in California, then that non-compete becomes unenforceable and really encourages employees to sort of flee the jurisdiction where they're at and to move to California to avoid their obligations under their restrictive covenants agreements. And we'll talk a little bit about how courts have dealt with that in recent years. Washington also has a unique statute that says, look, you cannot require any Washington-based employees to litigate outside of Washington or under non-Washington choice of law provisions. Massachusetts similarly has a provision basically prohibits avoiding the obligations of the Massachusetts non-compete statute by applying a different choice of law. Minnesota similarly has a statute, and Louisiana has a similar statute that doesn't necessarily outlaw it completely, but does require the employee to knowingly agree and ratify that provision. And again, not only do these statutes potentially make your non-compete unenforceable, but you could potentially create some liability for an employer who in California just has it exist, even if they're not intending to enforce it, or if they're trying to enforce in Washington, and I believe in Minnesota as well. Not only are you facing potential fee shifting, I think Washington also has a penalty. California allows for damages. I'm not aware of any case yet that's talked about, what are actual damages beyond attorney's fees that an employee might be able to claim for violation of the statute. But I'm sure some employee attorneys will try to get pretty creative, and we might start seeing some guidance from the courts as to what types of damages are available to an employee in California who's subject to an unenforceable non-compete. Next slide. So again, the common fight here is employer has employment agreements with employees all over the country. They have a home state choice of law and venue provision. They have an employee that lives in one of these other states that does not permit that employee to have to litigate their non-compete outside of their home state. So what happens? How do courts decide when and where these will be enforced? Unfortunately, I think a lot of these statutes do create a bit of a race to the courthouse scenario, because simply because California has decided that non-competes are not enforceable in California doesn't mean that the courts in other states have to agree, and many of them don't. And so oftentimes, a consideration that always comes up is, who can file first? Sometimes an employee, obviously doesn't want to incur the cost and expense of initiating their own litigation if they don't know whether or not their agreement's going to be enforced. So sometimes they'll sit back and wait. And the same thing with employers. If you're concerned, I've got a California-based employee or even not a California-based employee, but somebody who has, surreptitiously, there we go, moved to California, shortly before or after their resignation, and to try to take advantage of those laws. There's a lot of consideration about when and where to file. But ultimately, what will happen is if a court is faced with this situation, let's assume for a second that you have an employee that's based in Washington, employer's based, let's say Massachusetts, since that's where Don and I are, with a Massachusetts choice of law provision. Will a Massachusetts court enforce that choice of law provision? And again, setting aside the various other statutes that might affect that consideration, a conflicts of law analysis is performed by the court. And there's sort of two tests. These come from the restatement of conflicts, which most states have adopted. So this is generally the way courts that will enforce it, there could be some nuanced differences in the 50 jurisdictions, but generally speaking, those choice of law provisions will be enforced unless, and there's sort of two tests. One is the chosen state, so let's say Massachusetts in my example, has no substantial relationship to the parties or the transaction, and there's no reasonable basis for the party's choice. So this is really a pretty low standard. It's pretty easy to meet. So long as, let's say, the employer is incorporated or does, has their principal place of business in Massachusetts, that's going to satisfy the no substantial relationship test. And unless you've chosen some sort of completely random choice of law of another state that has no relation to either the employer or the employee, you're going to be able to satisfy that first test. The second test becomes a little bit trickier, and that is whether the application of the law of the chosen state would be contrary to a fundamental policy of a state which has a, quote, materially greater interest than the chosen state in the determination of the particular issue. And so again, usually using California as the example, most courts have and would find that that California has a fundamental policy against the enforcement of non-competes. I don't know that I've ever seen anybody be successful in arguing otherwise. There's same with customer non-solicits, employee non-solicits. It's a little bit of a gray area, but let's say for the purposes of this analysis, everybody agrees that California has a fundamental policy against the enforcement of non-competes. And so if you meet that test, then you move on to the next step, which is whether or not California has a materially greater interest than, let's say, Massachusetts in my example. And that's where it starts getting a little bit more complicated and much more fact specific. Oftentimes courts will consider things like, where was the contract negotiated? Where was the contract signed? Where was the contract performed? How much of the employee's time was spent in California? How many times did they visit Massachusetts for training? Where did their job take them? It becomes a more fact specific analysis about whether or not California has a materially greater interest. And again, it's the party who's challenging jurisdiction generally has the burden of showing that California would have a materially greater interest. And courts have really struggled with this issue in the context of non-competes, because oftentimes that is the situation. You have an employer somewhere else, and that employer state has an interest in enforcing the contracts of their citizens and the companies that do business there. And California certainly has an interest in protecting its citizens who are employees who might be subject to a non-compete. And so can we go to the next slide? And so what's become interesting with all of these states that are passing more and more legislation about non-competes, you don't really have the situation that you maybe had 10 or 20 years ago, where California was really this outlier who was the only state who was really litigating or legislating around non-competes. And you have these other states who have, to different degrees, have either restricted the enforceability of non-competes, or in some cases, are more employer friendly. But as more and more states legislate in this area, all of a sudden, this analysis of who has a materially greater interest in the outcome of a non-compete dispute becomes a little bit more challenging, right? It's not as clear cut as California says no and some other state says yes. Have California saying no and maybe some other state saying, well, maybe under these circumstances. And so if we go to the next slide, there was a recent decision out of Massachusetts in the First Circuit, a case that I think has been pretty well publicized, involving DraftKings, which is a Massachusetts-based company. And they employed a gentleman who lived in New Jersey throughout the time that he was employed at DraftKings. And as you can see here in the first sentence of the First Circuit's decision, it opens with this line: Massachusetts and California aren't exactly on the same page when it comes to non-compete agreements. And I'll give a little plug here for Judge Thompson, who drafted this decision. Usually reading judicial opinions is not the most entertaining thing in the world, but she sort of goes out of her way to make this decision a little bit more entertaining to read, much more casual language than we are usually used to seeing in decisions. So it's sort of fun to read. But anyway, the employee lived in New Jersey. He quit his job at DraftKings to take a similar job with a competitor based in California. DraftKings said you can't do that. That violates your restrictive covenant agreements that had a Massachusetts choice of law provision. And the employee argued, like many employees do, that because he had moved to California, again, shortly after his resignation or right around the time of his resignation, that because California has this broad ban on non-competes, that California had a materially greater interest than Massachusetts in the enforcement of his non-compete. And interestingly, prior to the enactment of the Massachusetts Non-Compete Act, which was passed in 2018, there was a decision from the Supreme Judicial Court of Massachusetts that did say sort of where you have a Massachusetts employer and a California-based employee against somebody who had been in California throughout their employment, that California did have a materially greater interest than Massachusetts in the outcome of a dispute over restrictive covenant. But here, the First Circuit actually came out on the other side, and their holding was really based on the fact that, well, Massachusetts has since decided to legislate in this area by passing their own non-compete statute. It doesn't outright ban non-competes. It simply creates some statutory requirements that employers must comply with. But the fact that that Massachusetts had legislated, all of a sudden sort of even the playing field, so to speak, between Massachusetts and California in determining who has a materially greater interest. And ultimately, the First Circuit came down in favor of DraftKings and enforced the agreement. And so it'll be interesting to see how this plays out in other jurisdictions in coming months and years as more and more states choose to legislate in this area. Again, there's a wide spectrum of what's enforceable and not enforceable in different states. So at least here, where Massachusetts and California were sort of on the two sides of each other, the court said no, Massachusetts had legislated enough to make it so California didn't have a materially greater interest. And I think that you'll start seeing this issue pop up more and more as more states legislate on these issues, as Don raised in the opening. And this is something we've seen increasingly happen, is employees who will move to California to take advantage of the very California or very employee-friendly laws that California has. One case that I handled recently that I always enjoy talking about is in that case, the employee was an executive of a company based in Iowa and had worked in Iowa for decades under an employment agreement that had a non-compete. And then he quit. He moved to California to take a job with a competitor. And, he said, look, I've moved to California. I've got a California driver's license. I've registered to vote in California. I've leased an apartment in California. Look, I'm living in California. I'm a citizen of California. And we thought, I'm not so sure about that. And as part of a forensic review of his employer issued laptop, we found that he had done some internet searching to figure out how long it would take to travel by private jet from his home in Iowa to the employer, who I think was located in Southern California somewhere. So of course we enjoyed sort of pointing that out to the court and saying, I'm not so sure that this is a legitimate move to California. Yes, maybe he's leased an apartment and maybe he spent some time there, but he's not really a bona fide citizen of California. And we've seen all sorts of different versions of this where employees try to at least cause the appearance that they have moved to California or they're in the process of moving to California. So it creates sort of another wrinkle in this analysis of whether or not California has a materially greater interest. I think that if an employee has been there long-term, lived there throughout their employment, I think courts would be more likely to find that maybe California does have a materially greater interest. But somebody who just showed up, a couple of weeks ago, I think employers have had some success in arguing that in fact California's interest in that dispute is certainly not materially greater. So again, with more and more states legislating in this area, I expect we'll continue to see employees try to take advantage of these laws and to move to other states. And it'll be interesting to see how courts deal with it. But at least recently here in the First Circuit, the court decided that no, simply moving to California does not mean that California all of a sudden has a materially greater interest than the home employer. If we go to the next slide. So again, in terms of drafting, coming back to sort of the purpose of today's presentation, in terms of drafting these types of agreements, employers really need to consider, what's going to happen jurisdictionally if and when it comes time to try to enforce these. And again, certainly just because an employee lives in another jurisdiction that maybe requires or prohibits enforcement outside of their home state does not necessarily mean that an employer cannot have, a home state choice of law. It creates some potential liability for sure, and that's something that everybody should consider. But again, just because the employee lives in a different state does not mean that everybody has to sort of agree with that state's policy. And it does create a bit of a race to the courthouse situation. But if the employer can get filed first in their preferred jurisdiction, as we saw in the DraftKings case, it doesn't necessarily mean that that choice of law provision will not be enforced. But of course, there's no guarantees there, and particularly in those states that raise or that allow for civil claims and fee shifting, that's another consideration that should be considered when drafting these. In terms of employees that are not in one of these states, again, usually you can satisfy the substantial relationship test pretty easily, whether it's in the state of the principal place of business. And very commonly, companies who have maybe offices all over will choose Delaware because that's their state of incorporation. Delaware historically has been viewed as a very employer and sort of corporate friendly jurisdiction. We'll talk a little bit shortly of that. I think that there's a shift that has occurred, and that Delaware is being seen more and more as maybe not so favorable of a jurisdiction, particularly in the Chancery Court, when it comes to enforcing these agreements. So employers should consider, if you have a little bit more flexibility in terms of what jurisdiction applies, I think it's important to seek some counsel, think about, which jurisdictions truly are more favorable. And even in some states, there's a big shift in federal versus state court. Here in Massachusetts, where Don and I practice quite a bit, we find that the federal courts are far more favorable for enforcement of agreements than state courts. And so another thing to sort of consider, what's the best jurisdiction for enforcement, again, if you have the flexibility to do so. Next slide. And then, okay, we're going to talk a little bit about some changes. Don spoke a lot about statutory changes. And again, the law is always changing year after year in different jurisdictions. Just wanted to touch on a couple of case law changes that have occurred in the courts, not necessarily in legislators, that should be considered in terms of drafting agreements. We can go to the next slide. So I want to talk a little bit about sort of the geographic scope of non-competes. Most states that have a statute don't give a lot of guidance on sort of what is a permissible geographic scope. Usually it's a reasonableness test. And so a lot of these decisions come down through the courts in terms of, what's reasonable and not. You're not going to get a statute that says this is, how you should define the geographic scope. And in Georgia, at least before a decision in a case called Wimmer in September 2024, Georgia courts had held that under the Georgia statute, non-competes were required to explicitly define the geographic scope of any kind of non-compete. And in September 24, the Supreme Court of Georgia reversed that and held that the geographic scope must be assessed for reasonableness. And you see the quote here: in light of the totality of the circumstances, including but not limited to the total geographic area encompassed by the provision, the business interest justifying the restrictive covenant, the nature of the business involved, and the time and scope limitations of the covenant. And this is pretty similar to the type of reasonableness analysis that most jurisdictions apply. But if you look at, a lot of these cases that, from a couple of decades ago, sort of before the internet age, you saw much more of an emphasis on the geographic scope of these restrictions. If you think about somebody who's sort of a door-to-door salesman who's driving around in his car, the geographic area in which he had access to confidential information, where he did his work, was probably much more limited. But in today's age, the digital age, where commerce is obviously taking place nationwide and worldwide at a much greater scale, courts have become increasingly more willing to enforce nationwide and in some instances worldwide restrictions. Obviously, again, it becomes pretty fact intensive. What was the employee's role in the company? What kind of information did he or she have access to? But I think the George decision is a nice reminder that courts really are looking at these geographic scope for reasonableness, and what is reasonable today, I think, is quite a bit different than maybe what was reasonable even 20 or 30 years ago. Next slide. All that being said, Delaware might be actually trending away from that a little bit. So Don mentioned the difference between blue penciling and Reformation states, and Delaware is a blue pencil state. And so judges in Delaware have the right to strike, overbroad provisions from a non-compete. And starting in October of 2022, in a case called Kodiak Building Partners, sort of it sent, I don't want to say shockwaves, but there was a departure from the way that Delaware courts had often been treating non-competes, particularly in this context of a sale of a business. So this was a sale of a business case. Again, Delaware often considered very corporate friendly. Sale of a business cases in almost every jurisdiction receive less scrutiny. And so it's pretty uncommon in Delaware for a court to say, we're not going to enforce a non-compete in the sale of a business. But that's what the court did in Kodiak. And what made the decision even more notable was the court had the ability to blue pencil it, again, to make it more reasonable. But the Chancery Court in that case opted not to. And in the years since then, there's really been a shift in that court where the chancellors in the Chancery Court, even though they have the authority and have had the opportunity to blue pencil what they viewed as overbroad non-competes, they've pretty consistently chosen not to. And you can see from some of the quotes here from some of these cases why that is. I think that those courts feel like by blue penciling overbroad provisions, you're effectively incentivizing employers to draft overly broad agreements. And then, like the Sunder Energy case said, it's a no-lose situation for the employer, right? Either the court's going to uphold the broad restriction, or it's going to narrow it a little bit to a more reasonable restriction. But in any event, the employer has an enforceable non-compete. But what happens to all those employees, for example, who don't challenge it, who don't litigate it, who just say, okay, I'm subject to this, either geographically broad or long non-compete, so I'm just not going to enforce it. Those employees will be harmed. And so the courts have said, look, we're not going to save employers who've drafted these overbroad agreements, even though we have the ability to, we have the authority to, we're going to choose not to do it. And that's certainly a trend that's developing in Delaware. Next slide. Because we're running behind a little bit, I'll work quickly through this, but there's been some recent developments in cases involving forfeiture for competition agreements and clawback. So a forfeiture for competition agreement, similar to a non-compete in that there's an agreement between the employee and the employer where the employee won't compete for some period of time. But the remedy is different. And instead of getting an injunction preventing the employee from competing, if the employee chooses to compete, he or she agrees to forfeit or pay back certain benefits that they may have received during their employment. The courts that uphold these kind of provisions refer to the employee choice doctrine. They say, oh, look, it's not really preventing an employee from working where they want to work. They have the right to go work there. They simply have to choose between retaining the benefits that they receive from their employer or going and competing. And so those agreements in some jurisdictions are scrutinized differently than non-competes. Other jurisdictions, Massachusetts is one, for example, they're reviewed the same way as non-competes. And I'll put a quick plug in here for Don, who's going to be arguing an important case in front of the Massachusetts Supreme Judicial Court on Monday involving the application of our state's non-compete statute as it relates to a clawback provision and an employee non-solicit case that we've been working on. Next slide. Again, we're running a little behind, so I'm just going to quickly move through this. But again, going back to Delaware, this two decisions from 2024 that really reaffirmed the employee choice doctrine in Delaware. The first was a case in January of 24, where the Delaware courts upheld these type of forfeiture for competition agreements against some high-level, highly paid folks in a partnership dispute. That left some question, though, about whether or not the employee choice doctrine would apply to more sort of mid-level rank and file employees. And then in December of 24, the Supreme Court of Delaware had another opportunity to analyze these agreements, and again reaffirmed their enforceability in Delaware, even against lower level employees. Basically, interpreting these as any other contract and not sort of doing a reasonableness test that you would for a non-compete. Next slide. And again, so for some employers, there may be a choice to be made here about whether or not asking employees to enter into just regular non-competes without a forfeiture is a better choice than having a forfeiture provision. Of course, the big difference is, you actually can't stop the employee from going and working for a competitor. Your remedy is to get paid back whatever the benefits at stake are. But if those benefits are high enough and the payback is basically hurts the employee enough, it sort of acts as a de facto non-compete, and in some instances may disincentivize a breach of a non-compete more than just a straight non-compete. So I will turn it back over to Don now, who's going to talk a little bit about other restrictive covenants beyond non-competes.
Thank you. I just wanted to mention we have already gotten a couple of really good questions. If we have time, we will respond to them on the webinar. If we don't have time, we will send you an email to the people who ask these questions, because they are really good questions. Next slide, please. So I think a lot of employers think non-competes are tricky, they're potentially risky. Let's just do away with non-competes and then we'll be good. That's not the case. As we have talked about throughout this webinar, even other covenants are now subject to some of these rules, including potential fee shifting or other situations where there's liability if you screw up the non-solicit. So here you will see a list of 9 states that have rules, whether it's a limitation or an outright ban on customer or employee non-solicits. I won't get into all of those because, again, we have limited time, but wanted to let you know about that. Next slide, please. This is what I think is really interesting, because I really do think a lot of people think, oh, NDAs, confidentiality agreements, non-disclosure agreements, those are fine. Of course, you can protect your confidential information. But we have now seen a couple of cases, at least, where courts have said, even this covenant is too broad. So, again, picking on California, we saw a case in 2020, the Brown versus TGS management case, where the court said this NDA is just way too broad. It incorporates way too many things that really aren't confidential, and you're not going to be able to enforce it. That was very surprising at the time, but that has been upheld since then in other jurisdictions. Most recently, last July, a federal court in Illinois made the same determination. They said, look, this confidentiality provision is way too broad. It includes everything under the sun, even things that aren't really confidential. There were carve-outs about, well, if it's something that's in the general public's knowledge, and the court said that's still not enough. Those exceptions do not save this. And it wasn't simply that the court said that's too broad, we're going to narrow it. The court said we are not enforcing this NDA at all because it's too broad, and you should have done your homework and drafted something more narrow. Wisconsin is kind of a weird state. A lot of states, they'll let you, if you draft it narrowly enough, you can say, as long as this information is confidential, you have to keep it confidential. But Wisconsin, for all covenants, not just non-competes or non-solicits, but even NDAs, you need to have a reasonable duration. So, we often say 3 years is a good duration. You can't protect confidential information beyond that period. Now, confidential information is different from trade secrets. As long as something is a trade secret, there's state, federal law on that. So you can have that as an exception, but generally for near confidential information, you're going to have a reasonable duration in your agreements for Wisconsin employees. Next slide. Okay, so we'll do a very, very quick update on the FTC and NLRB. Next slide, please. Many of you know that the FTC had announced a rule that would have banned virtually all non-competes. You may have also heard that a judge in Texas last year, just before it was set to go into effect, set forth a nationwide injunction putting it on ice. That case has been appealed to the Fifth Circuit. There was another case that came out the same way in Florida. That case has been appealed to the 11th Circuit. We believe that both the Fifth and 11th Circuits are going to uphold those decisions. And so we don't think the non-compete rule is going to go into effect. Not to mention the fact you may have heard we have a new administration in DC with different priorities. And Lena Khan, who was really the champion of the non-compete rule, stepped down at the end of January. The new commissioner had voted against the rule. But, not so fast. You got to remember that even the commissioner who voted against the rule has acknowledged that some employers do abuse these agreements. And the individual, Mark Meter, who President Trump has nominated to fill the final spot on the FTC, he has also said, as recently as Tuesday, that non-competes have been overused and abused. So the FTC can still go after individual employers who are abusing these agreements or applying them to too many people, too broad a scope, and the like. So it is still important, even though we have a new administration. Next slide, please. Similarly, the NLRB, under President Biden, there were a couple of memoranda that had been issued taking aim at non-competes and essentially saying that they interfere with workers' rights under the National Labor Relations Act. Since the Trump administration has come into power, the new acting GC has rescinded those memos. So there is going to be a new priority. I do think the FTC is more of a threat than the NLRB in this space, but that, it changes as time goes on. Next slide, please. So basically, where are we now? So you've heard a lot about legislative efforts that are ongoing, changes in case law, different agency priorities as administrations change. The bottom line is you really can't be relying on outdated forms. And I know that clients don't always like to hear this, but you really should be asking counsel to review these agreements. I think annually, frankly, is the best thing to do because things really do change quickly. And you want to be mindful of what is permitted and not permitted. And again, it's not just about, is there a new statute that prohibits this? Public opinion of these covenants is changing. So is judicial opinion. There are a lot of judges now that are fairly hostile, even though there may not be a statute prohibiting something. Judges really expect employers to be drafting their agreements narrowly and only to protect a legitimate business interest. So with that, I'm going to turn it back to Dallin, who's going to give some tips as to how you can really draft these agreements going forward so that they have a better chance of being enforced.
Yeah, so next slide. We're going to sort of wrap up everything we just talked about and sort of consider those factors when it comes to actually drafting these agreements. As Don said, the best, to me, the best agreement is a non-compete that, an employee complies with and you never have to seek to enforce it. The worst scenario is when you go to enforce it and it's not enforceable for one of the myriad reasons that we've talked about. But a couple of considerations that we usually come up against is, where do your employees work and where do they predominantly work? So where do they live and where do they work? For some employers, it's an easier task because if all of your employees live in one state or two states or in a sort of geographically limited area, those agreements are going to be a little bit easier because you're going to be able to track changes, any kind of legislative changes, and have an agreement that hopefully covers employees that live and work in different states. Of course, if you're an employer that has employees all over the country, that becomes a much more challenging task. And again, I'll do a quick plug here. Seyfarth publishes a 50-state desktop reference every year that gives sort of a little summary of all 50 states, which frankly, I still reference sometimes when, because while we try to stay abreast of everything that's going on, nobody can really memorize everything that's happened in all 50 states every year. So it's important to have those resources available. And so when drafting the agreement, oftentimes the consideration is, do you want to have one agreement for all your employees? Obviously, we've covered the risks there, especially if you have employees that live in states that don't allow certain provisions that might be in your non-compete. Rather than going with one agreement, another option is to have sort of state-specific addenda to the main document. So you'd have your one sort of standard non-compete employment agreement, and then you would have some different addenda that you've prepared for each of the states where perhaps you've got employees, and that would be added or attached to the back of the agreement. And then the third one is just to have one document with each state-specific provision in the document itself. The trouble with that is, as we've seen, that can get a little cumbersome if you're identifying every single state that has some unique statutory requirement that you're trying to comply with. All of a sudden, your agreement is ballooning to dozens of pages. And so there's certain administrative considerations there. Obviously, managing 50 different agreements for 50 different states comes with some administrative challenges. And look, even under the best circumstances, people make mistakes, right? The notice that you're required to give maybe doesn't go out at the right time. Like Don talked about, maybe the wage threshold, somebody's not entirely sure what the wage threshold is. So with so many things to consider, I think that Don and I probably agreed limiting the number of documents, number of agreements that you have to manage is ideal, so long as you're doing it in a way that covers all of your bases. And then, another thing that comes up sometimes is whether or not there's a concern with employees seeing lesser restrictions for coworkers in other jurisdictions. Maybe employees that live in some of the southern states that don't have these restrictions, they look on with envy at their colleagues in California who seem to be able to leave. And maybe does that incentivize this type of, fleeing to California or one of these other jurisdictions? An argument that we see quite a bit when we go to enforce these agreements is what we call the selective enforcement doctrine. And that is, hey, one of my colleagues left and went to an employer a year ago, and you didn't enforce the agreement against them. Why, you shouldn't be allowed to enforce it against me. And again, sometimes there are these jurisdictional issues that come in. And so something to consider in terms of drafting the agreements. Next slide. Again, not only keeping track of statutory requirements, but being aware of any kind of judicial changes, and even changes sort of in public opinions, right? There are, and I think it's regional. Sometimes it's by industry. We've noticed that some industries, enforcement of non-competes is looked at with aghast, right? I'd say the tech industry, because of its California roots, I think even companies outside of California sometimes are hesitant to have non-compete agreements, just because within that industry it's less common. Whereas certainly we've seen other industries where it's a little more common, and so some considerations in terms of employee morale and culture and things like that also go into drafting these. And again, trying to limit the agreements as much as possible. Obviously, you want to make sure they're broad enough to encompass protecting the legitimate business interests of your company. Oftentimes, that's confidential information and trade secrets, goodwill, and customer relationships. So oftentimes limiting it in a way that it limits it to what the employee actually did for their job for the company, and the access, what kind of access to confidential information did we have? You see here we have the janitor rule. This comes up all the time in overbroad agreements that sort of say you can accept no law, or excuse me, no job for that employer, that competitor. And the retort is usually, oh, what? So they couldn't go and be the janitor there in a position, obviously, where they wouldn't be in a position to misappropriate any trade secrets or confidential information. So I think courts oftentimes want to see, narrowly tailored restrictions that really don't prevent somebody who really wants to keep working, maybe even in the same industry. Is there a way that they can work that doesn't jeopardize the legitimate business interests? We've talked about geographic scope, duration. I think that 1 year is sort of, most states have coalesced about around 1 year being sort of the standard duration. Certainly less than that. Oftentimes, I think courts view these as on sort of a sliding scale. So maybe a non-compete that has a shorter duration, maybe they'd be more willing to enforce a broader geographic scope or a broader limitation on conduct. So maybe a 3, 4, 5, 6 month non-compete is enforceable and will be enforceable against broader interests. I think going past a year, you're going to start getting into some challenging areas and really have to be able to explain to a judge why more than a year is necessary to protect legitimate business interests. Next slide, please. And again, a few other terms that we like to include. And again, the note here is the weight of these acknowledgments definitely varies by jurisdiction, but oftentimes we include in these agreements an acknowledgement by the employee that the restrictions are reasonable and necessary, that alternative covenants are insufficient, that the employer will suffer irreparable harm in the event of a breach, and that the consideration that's given in exchange for the non-compete is sufficient. For some courts, I think courts that maybe are on the fence about enforcing, maybe these types of acknowledgments come into play. Some judges, though, I think they don't put much weight in them, but certainly no harm in having them in the agreement. And again, making sure that we include all the appropriate whistleblower protections, disclaimers about what type of information, for example, that an employee could share with a government agency, things like that. And then lastly, assignment, severability, modification. We see these in all agreements. But when you've got situations where you've got maybe, a company being sold and whether or not, those employment contracts are part of the transaction, you want to make sure that you have these types of terms in there to make sure that, you don't lose the ability to enforce the non-compete. And I think that's it. We want to tackle any questions or?
So why don't we switch the slide to the next one so that people can at least, see the CLE verification form and the code. While we are here, I will answer one of the questions real quick because it's an easy answer. Does the Massachusetts, the material change doctrine, does it apply to non-solicits as well as non-competes? Yes, it does. It applies to all covenants in Massachusetts. So you should include that provision that I talked about where you say any change, material or immaterial, will not affect the validity of the covenants in this agreement. You should include that even if you have an agreement that doesn't have a non-compete. There is a question about independent contractors in California. That's frankly going to be a 5-minute conversation. So we will answer that over email. Thank you all again so much for coming. We know we covered a lot of information. If you have any questions or concerns, please reach out to us. Let's go to the next slide just so people can see our contact info. We'd be happy to talk to you about this. As I said earlier, Dallin and I do this work all the time, and we are more than happy to assist you in any way we can. So thank you again, everyone, and hope everyone has a good day.